Good afternoon. This week we're going to be working on Chapter 9, Legal Writing, Form, and Substance, which you guys are going to get a lot of in legal research and writing, and you certainly have started down that path. But we're also going to hit some low writing before we get to the bulk of what you're going to do in the second half of your advanced legal research and writing class. So as a paralegal, you're going to do a lot of writing, whether it be summarizing medical records, cases, answering interrogatories, writing letters, doing research and drafting memos for your employer, or possibly briefs, whatever, whether it be to the trial court or the appellate court. In any sense, knowing how to write effectively is one of the greatest skills that you can have. And that's what we're going to talk about and do a lot of in class today. So let's go ahead and talk about some of the things that need to be covered. If you get an assignment from your attorney, and I can tell you early on when I was doing my internship while in law school, I would get these assignments sometimes from attorneys, and I would be completely lost because I had not been with the file since the beginning. They assumed I knew a lot of facts about the case, which obviously I didn't. And I would get a memo that would have like 3 sentences, and they'd want me to do extensive research on a particular legal issue. So sometimes what you need to do is, first of all, when you receive an assignment, if your boss gives it to you orally, say it back. Make sure that you're both saying the same thing. If you receive it in writing, and it, depending on how the person you work for likes to correspond, you may need to email back with further questions. Sometimes it can be beneficial. Don't waste a big chunk of time digging through a file, especially if it's like huge. But you may need to go through and familiarize yourself somewhat with what is in the file. And as we discussed, there is a la court out there that will allow you to go on, look and see what pleadings have been filed. If you don't have a paper file, or if maybe the file is electronic and you're not familiar with it, that's a good kind of a snapshot of what's going on in the case. So those are just a few key things to keep in mind. Make sure you understand the assignment. Big check off point. Understand that when you receive an assignment too, one of the questions you need to know before you walk away is, when is it due? Is it, a week from now, 10 minutes from now? Whatever the case may be, make sure that you know what your deadline is so that you make sure that you get your assignment done and you have time to review it, and certainly talk to your boss about it. Then you gotta decide, well, what exactly am I writing? What kind of analysis is going to need to be used? Is it a persuasive document? In other words, you're trying to talk the court or the opposing counsel into something, or is it just informational? That's another thing that you have to think about before you start. A couple other things to consider is who is reading this document. Is it somebody that understands the subject matter? Is it for a client that really has no idea what to expect, and you would need to go into a lot more detail, especially if they lack the expertise and are unfamiliar with the key facts or concepts? Also, you got to decide, most documents, if you're going to write something for a court, you're going to put your best arguments forward first, your best points. But sometimes to get to that, you want to go in a logical order. You don't want to be jumping around all over the place and losing your reader along the way. So those are considerations as well. One of the biggest hurdles that I had when I first started writing in a legal format is to use the active voice and not a passive voice. A lot of times lawyers get a bad rap because they say that we write weird or strange, and although I will agree that we do use some words that might be unfamiliar, the structure in which a lawyer writes is pretty much the same. You have transitional words, your words have definite meaning, it means what it says, and you don't want to involve flowery words, for lack of a better term, for all my friends in the English department. You're not trying to make this an eloquent, moving piece of written work. Of course, I guess you want it to be moving if you're writing it to a judge, but what you're wanting to do is to be very clear, very concise. Don't make the judge, the client, whoever it is reading it, have to guess at what it is you're trying to say. If you have multiple points that you're trying to make, headings are fine, bullet points are fine, as long as it's a good guidepost to clarify your reader through the document. That is perfectly acceptable. Active voice and passive voice is one of the things that I sort of had a hard time wrapping my mind around when I first started thinking about it, and when I would get some of my first papers back. And we're going to go over in class Exhibit 9.2 that talks about writing concisely. It gives examples of wordy versus concise language, so we will cover that during class. One thing that happens a lot in legal writing is, especially if you're drafting a brief, I think of that specifically, and you're quoting language from a case or a statute. What you don't want to see in a particular brief is just quote after quote after quote. There are certain things within a case that are going to be important, and obviously you do want to quote them, but you need to include your own language as well, so it doesn't just look like one run-on quote from a case right after another. So I would caution you on writing in that manner too. If there's one particular point that I cannot emphasize enough, it is to proofread. All of us make mistakes. It's going to happen. I would suggest and recommend, and I do this myself, if I have a document that I need, that I'm about to file or turn in or whatever, I certainly do not rely on myself. Only because sometimes, especially if you're tired, you can be working on a particular document and you can read it and reread it and still miss, careless errors and mistakes. So I always would suggest allowing somebody else in your office, a friend, as long as it doesn't divulge any, information, but allow somebody else to put a separate and fresh set of eyes on the document that you're about to submit or turn out for, possible errors. And I would suggest too that you create forms of your own, form letters, so that you're not constantly having to reinvent the wheel. There's going to be several letters that are just going to be basic, and you're going to send them out in almost every case. Dear Mr. Smith, thank you so much for contacting our firm. We are excited to be working with you. I have enclosed for your review a copy of our attorney-client agreement. Please submit it, return to us within such and so days with your signature, and we will be glad to get started. I mean, that's just an example. Or a motion to continue in a case. There's some letters that you're just going to send over and over. Keep a form of it. Just be sure to always put, proofread and make sure you have the right name, address, and information, and you don't send it out to the wrong person or with information in it that would not pertain to that particular person's case. If you send that to a client, then they think that you're careless, and it gives them an uneasy feeling, so you certainly don't want that to happen. Okay, I'd like to turn your attentions to Exhibit 9.3 in your textbook. It's on page 262. And it just gives the general overview and outline of what's going to be in letters. You're going to have your date, your method of delivery, address, reference line, salutation, the body of the letter, closing, a signature and title, initials of the person who wrote the letter and the typist, and then others receiving copies of the letter. So that's a good general format to follow. Think about, or some typical letters that you're going to be writing are informative letters, confirmation letters, opinion letters, and demand letters. And we'll go over the samples of those different kinds of letters in class. One thing that we'll touch on as well is a memorandum of law, and we'll definitely get into a lot more detail about that as we go along. One particular section that I would like for you to really focus on is the idea of IRAC. It's an acronym used for, the I stands for identify the issue. R means you explain the rule that comes from it. The A is the analysis, and C is the conclusion. That is how the discussion section of a memo should be organized. Okay, so in class this week, we're going to do several exercises that involve writing, and I will go ahead and put those assignments out there on Blackboard as well, and we will work on them in class.